Michael Stevenson.
Okay,
Hold on one second.
this is case number 2500763 AV Gratiot Square LLC versus Liquor Basket Gratiot LLC.
Council appearances for the record.
I'm Michael Stevenson, Your Honor. I'm counsel for the appellant Gratiot Square.
Good morning, Your Honor. Attorney Elizabeth Ellison, P820998 for the appellee, Liquor Basket Gratiot.
Okay, and Ms. Ellison, this is your motion relative to it has to do with the timeliness of the filing. You know, one thing I see here that the order was entered on December 27th.
That is correct, Your Honor.
Your Honor, if I may respond, the order was signed on December 27th. There was no notation in the Register of Actions that the order was entered that day. We monitored the entry of the order throughout the proceedings, and we didn't get notice of the entry of the order until January 10th when we received the order in the mail. And that's detailed in the affidavit that I attached to the response to the motion to dismiss.
But you know, I understand what you're saying, but where's the case law that supports that? Because the court rule says when the order is entered, and also I don't know if you did, but I didn't even get a copy of the Register of Actions. You didn't attach a copy of the Register of Actions. You want the district court? You're talking about the Register of Action for the district court, right?
Yes, and I was sure that that was attached to the response, but in any event, it was attached to the appeal documents that I filed at the time that I filed it.
Well, I'm just dealing with the motion right now, and
Okay.
that's what I have in front of me, the motion. But you know, it's like the court rule says, and when the I forgot I had the language.
4.20102, Your Honor, states that an appeal as a matter of right must be filed within 10 days of entry of judgment.
Right. So I don't know how you expect me to get around that,
Well,
Mr. Stevenson.
Your Honor, as I indicated in my response, I'm asserting that we have an appeal as of right because we were not served with the order until January 10th, and there was no way for us to determine when the order was entered because it didn't appear on the Register of Actions at the time. So we wouldn't have known what the deadline for the appeal was. Even in the cases that the case that I cite, Chin versus Wayne State University, and the cases that the appellee cites a case from 1917. And if you look at the language of that case, it even implies in that case that notice is required of when the order is entered. But in addition to that, even if the court determines that the appeal was not filed timely, the court rules provide that doesn't require the court to dismiss the appeal. The court has the authority to grant leave to appeal. And in addition to the response to the motion and the prayer for relief in the motion that the court treat the claim of appeal as a request for leave to appeal. In addition to that, I filed an application for leave to appeal at the same time. And if the court decides that the claim of appeal was not filed timely, I would request that the court entertain the application for leave to appeal. The application for leave to appeal was filed timely within the time limits of that. I think the court has 35 days to make a decision about that. My argument is not that the appeal was not filed timely, but if the court is so inclined to determine that it was not filed timely, that I would request that the court would entertain the application to appeal and grant leave to appeal over these issues. And that is clearly within the court's authority under MCR 7.105G.
Your Honor, may I respond to that?
Yes.
What's before the court right now is an appeal by right. The court does not have jurisdiction over that appeal by right. The appellant cannot now say it's an appeal, a leave for appeal in this case. He would have to file a whole separate case because the original case before the court is appeal by right. If the court doesn't have jurisdiction of an appeal by right, it has to be dismissed. He can't now then, say, I want to leave for appeal, because then everyone would do that, Your Honor. That's not how it goes. If the court does not have jurisdiction, the court's only option at this time is to dismiss the appeal.
Your Honor, I would strongly disagree with that. If you look at the text of the cases that were cited, even the cases that were cited by the appellee, the Schlega case indicates right in the text of the case that the court doesn't have jurisdiction to hear an appeal by right if it's filed untimely, but that the whole issue of whether or not the appeal goes forward could be remedied by the appellant filing a timely application for leave to appeal. And the case doesn't need to be dismissed just because of the appeal not being filed timely. The cases indicate very clearly that the circuit court has the authority to grant leave to appeal, even of an untimely filed appeal. It says that right in the court rules, and it says it in the cases that I cited, as well as the cases that the appellee cited.
Briefly, Miss.
Your Honor, I disagree with that. They filed an appeal by right. It is untimely. Therefore, the court lacks jurisdiction to hear the appeal by right. If he wants to file a new case for a leave for appeal, then that is their right, and we'll respond accordingly. But that's not what's before the court today. Is their original appeal that they filed timely? It is not timely, Your Honor. Moreover, I told them in January that it was untimely, so they had the chance in January to file the leave for appeal. So this isn't a new thing that we're going back and forth on.
The fact of the matter remains is that this is an unfortunate situation that arose because, and maybe it was because it was a holiday, that the district court did not follow protocol and get the order entered into the register of actions in a timely manner. And as Mr. Stevens has indicated, once he received the order, he responded within the time frame of his receipt. But the court rules clearly say in terms of when that the time frame runs when the order was entered, and we know that that was on the 27th. And the court inquired as to Mr. Stevenson as to what relief the court would have, because the court rule clearly says relative to the date when the order is entered. And so we do have an issue there, but the court does note that it was not necessarily the fault of the proposed appellant, but that the court didn't enter that as they should, and he did respond once within a time frame once he received that. In terms of the court does have the ability, the court has the ability to grant leave when it feels that it's appropriate, and the court feels that Mr. Stevenson's error in the timing was not of the fault of his own, even though the court rules don't truly address it, but it was a procedural issue that took place within the district court. That being said, the court is going to allow the application for leave to appeal to be submitted to the court. So and that's the basis for which the court is going to allow the appeal. So you can file your a separate application for leave because you did address it here.
Your Honor,
About
I'm sorry, I don't mean to interrupt, but I filed an application for leave to appeal at the same time I filed the response to the
Let me-
motion. So
let me
that's
check.
already on file.
let me check.
But Your Honor, if I may respond to that.
No, not. It's his motion. He gets the last opportunity. Thank you.
It was my motion, Your Honor, and he didn't motion anything.
Go ahead.
Your Honor, if the court lacks jurisdiction, therefore the court can't decide it, he would have to file a separate action for his leave to appeal. You allowing his leave to appeal is fine, but I'm entitled to respond to it appropriately. If it's not motioned up before the court, doesn't matter that he filed it. The only thing before this court today, Your Honor, is my motion to dismiss due to lack of jurisdiction, which I think you agree that it was untimely.
But I'm not going to dismiss it now. I'll put this over and to give Mr. Stevenson an opportunity, but let me open this up, please. When are you saying you filed this, Mr. Stevenson?
Just 1 second, Your Honor. It should have been April 28th.
He did file it on April 28th. Oops, I meant to close that. So he filed, so if you want to respond to that, but I'm not granting him leave. I'll adjourn this, where are we, the 20th? About adjourn this, yeah. Okay, well, I'll adjourn this to June 27th.
Till June 27th, did you say, Your Honor?
Yes, sir.
Okay.
At 9:45, because the application for leave is here.
Correct, Your Honor, but it's not noticed up, and I do believe it has to be filed in a separate proceeding. If you allow him to transfer this to an application, don't you think everyone who is untimely in a landlord-tenant action would then be like, okay, well, no, now I want an application to leave? That is not the process of the court or the appeals.
Mr. Stevenson, do what
Your
you
Honor,
feel is,
that's exactly the process. You don't need to dismiss this case
I'm not,
in order to entertain an application to,
and I'm not, I already said what I'm doing. Mr. Stevenson, notice yours up for the 27th as well. We'll see you then at 9:45. Thank you both.
all right, thank you, Your Honor. Your Honor,
Yes,
there's just one other thing. I guess the scheduling order would have to be changed because the scheduling order indicated that the appeal would be heard on the 26th of June. So
I'm sorry.
I think the scheduling order that was issued in the appeal case indicated that the
Yeah, the oral items were to be
would be on the
26th.
26th. So
Okay,
that,
but yeah, I'll deal with my law clerk on that.
all right, thank you, Your Honor.
Thank you.
You
We'll
said
see you on the
11:45?
9:45 on the 27th.
Okay,
Thank you.
thank you, Your Honor.
Thank you, Your Honor.
Yeah.